Okay, we will get started. Thank you for being here for our work session on Tuesday, July 25th. And we get to hear tonight from our legal department, and I'll turn the time over to our attorney, Clint Drake.
Thank you, Mayor. It's my pleasure tonight to get to introduce you to our legal department. I think since the last time we did this, it's all new faces. So kind of exciting. So we'll first hear from Heather Waite-Grover, who is our Assistant City Attorney and City Prosecutor. She's going to go over the SMOT table for you, and obviously she'll go into more detail about that. And then we have Allison Sorensen here with us, who is our new victim advocate. And then we actually have Becca Weidenhammer here with us, or Rebecca, if you want to be more formal. She just graduated from and received her paralegal certificate and is now enrolling at the University of Utah. So we're hoping to keep her for a couple more years until she decides to go to law school. So we're happy to have them. And they asked me how many people were going to be here today, and I said there'll probably be like 2 or 3 people in the audience. So I want to thank you, the 2 people in the audience, for being here. So anyway, I just want to say how much I appreciate these 3. And then there's one other who many of you might know, Lana, who is just, they're a great team, and I appreciate all they do for the city. And I think you're going to see what a value and a valuable team we have, here tonight. So I'll turn the time over to Heather.
Thank you. I appreciate this chance to go over what's frankly a very boring chart with you, but it's something that helps me do my job better, and it's just something that we need as part of our city code to make sure that we can appropriately prosecute violations of the city code. So Bountiful's a shared master offense table is basically a list of every possible way you could violate the city code. And it includes with it a number of data points about those ways to violate the code. So today as I present, is that because of my... Okay. Zoom. Is that better? That's what okay. I use WebEx all the time. Recording in progress. Okay. I will just did this now. I'm going to let the expert this. Okay. Okay, thank you so much. So let's get back to our slideshow. All right. So tonight I'm just going to give you kind of an introduction into what our current SMOT, our current shared master offense table, has on it and why we need to update it. Then I'm just going to go through a general explanation of criminal offense levels and punishments so you can kind of understand what these data points are on the list. This is also the same information that I shared with the department heads who helped give input onto this table. I'll explain just briefly what I can do as a prosecutor when I am prosecuting violations of the city code, so you can understand a little bit about how it's implemented in a practical manner. And then you obviously have a copy of the recommendations, and I can go through those in any more detail that you may need and then answer questions. So the 3 most important data points in the shared master offense table that I'm asking you to approve or weigh in on tonight are not only the name of the offense, but the level of the offense, the severity of the offense, and the standard fine for committing that offense. The challenges with our current SMOT is that it's just incomplete. It has about 114 violations of the city code on there, but it's missing 109 of them. So there's a lot that aren't on there. Some of those that are listed on the SMOT have some fine amounts on them, but they're generally outdated. as in a lot of them are like 20 bucks. My assistant Lana, who's worked with the city for 40 years, said, I think at one point we just charged $25 for everything. So that gives you maybe a sense for where some of these are still situated. The other challenge that I have is just that the basis for those fine amounts are generally unknown. There's about 3 or 4 code sections that say, if you violate this, the fine is X amount, but the rest of them aren't designated. And I think it's important for a legislative body to designate those, not just me as a prosecutor. I do have some guidelines that the state gives me, but I think just as at the state level, a judicial council creates fine amounts for the state code violations, I think it should be the city council that signs off on these fine starting points for city code violations. And then there's just some out-of-date portions. Code sections have changed, been revised, and we just need to get it up to date. As I went about preparing this updated version of the SMOT, I did meet with all the department heads that I've listed here. I specifically went over every code violation with them that's kind of under their jurisdiction. They now know a little more about being a lawyer than they want to. But it was from them that I got a better sense of which code violations are more severe, have more of a safety element to them, versus others that are just a little bit more about an orderly society, orderly town. And so it was with their input that I made some recommendations for severity levels. This is just the general information that I gave the department heads that I think is important for you to understand as a city council about offense levels and punishments. The state law allows cities to create codes, obviously, and then they can designate the violation of those codes as one of 3 things. First, an infraction, which is the lowest level of any kind of offense. You can think speeding ticket. Then the next step up is a Class C misdemeanor. And then from there, the next step up is a Class B misdemeanor. And I realize I am not sharing my page, am I, Miranda? Yeah. Okay. Let's hit Zoom. Share screen. Okay, this thing. There we go. Now you can see. And then the next level up from there is a Class B misdemeanor. Now the state itself can make violations that are infractions, Class C, Class B, but then there's also a level called a Class A, and then all the way up to things like felonies, which are more severe things that can include like murders, some serious theft, fraud, that kind of thing. This table gives you kind of a sense for the default that state allows for these different kind of offenses. We'll start at the bottom of this chart here with an infraction. If you commit an infraction, there is no way ever that you could go to jail for that. If you get a speeding ticket, you can get fined, but you're never going to end up in jail because you sped. With infractions, the state law allows itself as well as the cities to impose a fine up to $750, but not more than that. The Utah, as I mentioned, there is a state fine schedule, a state SMOT, if you will, and it gives recommendations for violations of city code. And if there is a violation of a city code that's an infraction, it recommends a $110 fine unless a city council designates otherwise. So you can generally go up, but if we don't designate anything, the state recommends that the fine be $110. With Class C misdemeanors, this is where jail time is a possibility. The maximum a judge could ever sentence anyone for committing a Class C misdemeanor violation is 90 days. Again, you can fine someone for a Class C misdemeanor, but no more than $750. And if a city doesn't designate any particular fine, then the state recommends you impose a $110 fine. With a Class B misdemeanor, you can be sentenced to up to 180 days in jail for that. The maximum fine allowed is up to $1,000. And if a city doesn't designate any particular fine for their Class B misdemeanors in the city, then the state recommends that the fine be $350. So you can kind of see how there's gradually an increase of severity in both fines and potential to go to jail. I will note with this that it is very rare for anyone, it's very rare for anyone to be sentenced to jail on a Class C misdemeanor, even if you've got a criminal history as long as, you know, your lifetime. There's a whole sentencing matrix that the state has, and it recommends when a judge should sentence someone with jail versus probation, and it is pretty much exclusively probation for Class C misdemeanor violations. And even for most Class B misdemeanor violations, the recommendation is probation. You only start getting into some limited jail time if you're committing a Class B misdemeanor that hurts a person, like assault, you hurt someone's body. The last column in there is probably the hardest to explain, but is important. It talks about whether or not a person has to personally appear in court before a judge to resolve their case. Now, with infractions, you almost never have to appear before a judge to resolve your case. If you get a speeding ticket, you'll be charged with an infraction. The fine is $130. You can walk into the district court, pay that, walk out, and you never have to talk to a judge. And that's true for most infractions. Class C misdemeanors, it's a little more 50-50. Often people have to go before a judge to resolve it. And then almost all Class B misdemeanors, you can't just go pay a fine and be done with it. You do have to at least appear once before a judge and enter a plea there. So that's kind of how the basic parameters work for the types of violations the city can impose. As I mentioned, there is a Utah Sentencing Commission. It has a whole matrix for about whether you should do jail time. It's based on things like your previous convictions, what type of convictions, are you hurting people or are you just hurting stuff? Have you been on probation before? And as I mentioned, probation is almost always the default for Class C and Class B misdemeanors. So very few people will, I mean, even if they're convicted of a violation of the Bountiful City Code, the idea that we're throwing a lot of people in jail is going to be not very likely. I wanted to kind of give you a sense for fines. The previous chart outlined kind of the maximums. These are just examples from the state code SMOT for their fine table. And these are kind of the starting points for fines based on violations of state code. The column to the left is just Class B misdemeanors. As you can see, they kind of range from about $690 for things like possession of a controlled substance or retail theft to more severe. The DUI is probably the highest fine imposed for a Class B misdemeanor. Assault is more severe than retail theft. When you're talking Class C misdemeanors, the fines under the state code tend to vary from $100 to up to $510. There are a couple that are Class C misdemeanors that get up to $750, but most are in that range. And then for infractions under state code, most of them are around the $100 mark. There's speeding, that's $130, but less severe things like parking is $40 or failing to register your vehicle is $50. But things that are a little bit more intrusive on society, like littering, can be more. So that may just give you a little bit of a sense for how the Judicial Council at the state level is thinking about fines. Now, under state law, there's some parameters that the state has for mandatory appearances on Class B or C misdemeanors. If a legislative body wants, they don't have to make an appearance mandatory on a Class B misdemeanor or a Class C misdemeanor. You as the city council can say, we don't care on this Class C misdemeanor, people can just walk in, pay the fine, we don't need them to go before a judge. Unless it's a domestic violence related thing, which we don't have in our code, or DUI, which I don't believe we had in the code. But we do have some violations that would affect a victim, an individual, or we do have some violations that might require restitution either to the city or to individuals. And so those are some where the state says, no, they need to go before a judge to resolve that. And this is kind of the reason why. If an appearance is not mandatory, that means a city prosecutor or a state or county prosecutor may never even know that someone was charged with that. All the people who get speeding tickets in Bountiful and just go pay the fines, I have no idea that that really happened unless I go actively looking for it. But if an appearance is mandatory and they have to go before a judge, then that case gets put on the calendar, and then I have to look into it, which means I read the report, I look into the person's criminal history, I look to see if there's restitution that's owed to somebody that was hurt. I try to get a sense for, whether this person's a first-time offender or this is, one of many violations of the law. And then it allows me as a prosecutor to go in and make an offer to that person for what I consider to be a just resolution of the case, and also to make sure that any victim is protected. And that's a way where I can get a little more creative and hopefully helpful to the city and the community when I can be involved in part of that process of pleading guilty to something. When it comes to that, on the subject of my authority, as a practical matter, very few people end up pleading to exactly what they're charged with, whether they're charged under state law and likely under the city code as well. Generally, there's a plea agreement process where we negotiate some things. I decide what's important in resolving the case, see what I can, offer them in terms of like sort of the carrot and stick, making sure we're taking care of what needs to be taken care of in the case, but also not bogging down resources with having to go to a trial for every single case. In that process, the state law allows me to amend offense levels down up to 2 degrees. So that means someone could come in with a Class B misdemeanor and I can say, all right, so this will look a little better in your criminal history. If you plead guilty to this and pay your restitution to the victim, I'll amend the charge down to a Class C misdemeanor. Or I can move a Class C misdemeanor down to an infraction, which rarely appear in people's criminal histories. Or I can even move a Class B misdemeanor down to an infraction. But the important thing to remember is I can't go up. I can't say, oh, this is an infraction, but this really was a serious thing, so I'm going to now treat it like a Class B misdemeanor. I don't have authority to go up. I only have authority to go down with some leniency. Also, as a prosecutor, I have the authority to dismiss charges, some of them, all of them. I can dismiss them contingent upon a person doing X, Y, or Z. I can do that before I bring the charges. I can do that after I bring the charges. And this is a handy tool if what we're really concerned about is compliance. And that's often what may be coming at issue in a lot of city code violations, especially when we're talking with things with the planning department or the engineering department. And we're not trying to throw people in jail. We just need them to honor the setback for the new garage they're trying to put on to their house. And if they're not cooperating with the engineering department and they're not taking them seriously, people take the prosecutor a little more seriously, for better or worse. They returned my phone calls last month very quickly when they've been dodging the engineering department for like months, years was it like? And then of course I can secure restitution or other conditions as part of a probation. So with that, when I met with the department heads, I presented them with all this information, kind of the method to the madness of criminal prosecution. And when they made recommendations that are in this table I've presented to you for approval, they were first based on things like community safety. Second, they were based on just general ideas of what's fair and proportionate for that kind of violation. And we also looked at how things were treated under state law so that we're kind of on par with that, so that it's not better to violate, a similar law in Bountiful versus a state law. We also looked at the interplay with non-criminal actions. For example, there's a whole administrative process that often city departments go through to try to get compliance. There's also things that can be done, for example, with the animal part of our code. The county, we contract with them to do animal services. They have some tools in their toolbox that a prosecutor doesn't have, like if you keep violating this, we're taking your dog. Or, you know, if you don't handle this vicious animal, then we're going to abate that nuisance, which unfortunately would mean, you know, killing the dog, putting it down or something. And so we may not necessarily need a huge, heavy punishment on the city level with fines and those sorts of things, because that aspect of the violation and those consequences are probably enough of a stick to get people to comply. And then we also talked about mechanisms for obtaining compliance, which is how severe do we have to make an offense under city code to just get people to clean up the junk in their yard, or to, respond to a stop work order, or other things like that. And, to the extent that the prosecutor's office even has to get involved with this, how much do we really need to get that compliance going, rather than just, seeking out punishment? I think, as I've worked for Bountiful City for the last year and a half, worked a little bit with the different departments. I don't do tons, but a little bit. And then just generally have been a resident of the city for the last 8 years. I think the general feel for the community approach to local government is this. On the one hand, there is a preference for law and order. We think people should abide by the rules, but there also is a lot of concern about heavy-handed government. And so there is, we don't want government regulating every last little bit of our lives. And so there's kind of that balance between, how do we use the lightest touch to just get what our community needs. A couple of the things that were not factors behind the recommendations were drumming up more work for the prosecutor. Completing this table isn't to try to encourage the departments to send more code violations my way unless they need to, or they feel need to, or that's eventually the direction that the city council goes. I've got plenty of work and I don't want any more. And so this is more just to clarify things so that we have a complete list. Additionally, I'm not trying, again, with not trying to drum up more work, I'm personally not trying to change Bountiful's approach to code compliance. I'm not trying to discourage or intervene with the way a department may administratively handle these things. I just want to, again, have a kind of a clarified approach once a department comes to me and says, it just hasn't been working, as we've tried to make efforts with this individual, we need you to get involved. So if there is any changes with how Bountiful City approaches code enforcement, that's not my policy decision to make. So I'll just wait for the people who do make policy, which of course is you, to designate that. Again, this is just for clarity. Before I talk about just some brief highlights of what the recommendations were, I also wanted to point out that going forward, the plan is to make sure that this table gets updated as the city council either passes new ordinances or revises them or repeals them. So it's more of an ongoing process and we never have to come to you with 109 new things to review and approve. And then I also do intend to just come before you once a year with any minor changes that we might need. Again, at the state level, the Judicial Council does an annual review of the fines, and I just think it's appropriate for the legislative body of the city to do an annual, at least glance or look at this to make sure that there's nothing that needs to change. With respect to the changes itself, I'll just go kind of by sections. In the criminal section of the code and the parking section of the code, the general feel from the police department was that that our code severities and fines should largely match the fines and severities for similar charges in the state criminal code. Again, that was the idea that it shouldn't be better off to violate a traffic ordinance here in Bountiful than a traffic ordinance elsewhere. So with respect to that, their fines match more of what you saw on that table, like the $690 fine for retail theft for most Class B misdemeanors, something closer to $250 to $300 for most Class C misdemeanors. And when I'm talking about the criminal code, I'm talking about section 10. And then something more like 100 for infraction violations of the code. There are a handful of criminal code sections that we will need to eventually probably repeal just because they're repeated in state code. So that recommendation's on there, but we can address that at a later time. When I spoke with the water department for some of the violations that are in section or chapter 6 mostly 4-102 and beyond, they actually the director recommended increasing the severity from Class C to Class B for those violations that had the potential to contaminate the entire city's water supply. And then keeping at more of a Class C level those kind of violations that didn't, such as outside watering restrictions. And we don't want people watering when they're not supposed to, but that's not going to contaminate the entire city's water supply. With respect to some of the things in parks, one thing they moved down was just leaving plastic flowers in cemeteries. It was currently a Class C misdemeanor. They didn't think anyone needed the potential of jail time for doing that, and maybe an infraction and a $100 fine was sufficient. In code section 8-2, -107 and beyond, that's our animal code. This one had probably the most significant recommendations for changes. As it's currently written, every possible violation of that code is a Class B misdemeanor, which puts it on par with retail theft, assault, having marijuana, DUIs, although DUIs are the most severe Class B misdemeanor. I just didn't think that accidentally having your dog get out of your yard was a Class B misdemeanor. I think that'd be more appropriate as an infraction. If your dog is found outside of the yard more than 3 times in the space of the year, animal control does have authority to impound your animal. And so I think, fining people $100 is a little more proportionate to that. And I felt that way even before I became a pandemic dog owner. So things like cruelty to animals obviously should be more severe. Things that have more implications for human safety, like 8-2-142, duty to report bites, Class C misdemeanor. But having more pigeons than you're supposed to, 8-3-101, I think it's more an infraction level. And so that's what the recommendation is. Now, with respect to mandatory appearances, the general idea when I spoke with the department heads was this: if we want to help secure compliance over punishment, we would prefer for these offenses to be mandatory appearances, because that means that it would get put on my calendar as a prosecutor. I would read the report, and then I can offer those more creative solutions to residents who are struggling to comply with having too much garbage on the yard, building a structure that they're not supposed to build, so that I can say things like, hey, you meet with the engineering department in the next 30 days, you actually submit some plans to them, and if you get right with them, then I'll dismiss the charges. And so to the extent we are requiring mandatory appearances in this, it's again not to be punitive, but mostly to give me as the prosecutor a chance to help secure compliance without needing to be too punitive. So when you see those there, again, that was the same conversation with the planning department. They know that I can negotiate with people, but that only works if they're in front of me. So with that kind of general overview of some of the changes and some of the reasons for the changes, I'll go ahead and take any questions that you may have, but I'm also mindful that I don't want to take too much of Allison's time, unless she wants me to take more of her time. Yes, I can unshare my screen.
Any questions, council?
Can anyone hear me by any chance?
Yes, Cecily, we hear you.
Oh, okay. I have a question.
Okay.
Is that okay? All right.
Yes.
All right. First, I want to say, Heather, thank you so much for all of the time and effort that you went into preparing this SMOT update. I think this is clearly long overdue and is going to really be a great thing. I really appreciate the compliance-oriented nature of how you've approached this. And I, for one, really think that the annual recommendation is an excellent suggestion. And also just thank you for helping guide us as a city in our efforts to have transparent and understandable, findable information for our residents. I know they always appreciate when they know that there's a fair and consistent process. So just first, I wanted to say that. The question I have is that it seems that there are many infractions that will now require, as you pointed out, the mandated court appearances for the resolution of a case. And again, with what you had mentioned, that the focus will be on compliance and not punitive measures, which I think is just spot on the right approach. So I appreciate that. But I'm wondering how this will burden our city judicial system and how it's anticipated that potentially so many more mandated court appearances might impact the funding of your department or city resources. And do you feel like maybe this is something that would be addressed in the annual review? It had like next year, or maybe might need to have a more frequent review where you were able to see, okay, here's actually now with this many mandatory appearances, maybe we're needing additional support or additional resources.
Yes, so in terms of increasing my workload, I don't anticipate approving this SMOT to immediately increase it. A lot of it will just depend on the individual departments and whether or not they feel they need the assistance of a prosecutor to secure compliance. A lot of that is frankly dependent upon how much resources they have to observe code violations and then try to address them themselves and then have to come to me. We currently do not have any dedicated officer for just code enforcement. All our police officers are police officers. So they're not really going around looking for people who have noxious weeds in the yard or billboards in the wrong place or, those sorts of things. My understanding is that aside from the observations that can be made by planning department or the engineering department or the water department, we don't have anyone patrolling the neighborhoods looking for this. And so we rely on citizens basically to report concerns. And then when they do report the concerns, that's when it gets to the attention of the departments and then possibly comes across my desk. So unless Bountiful City changes that, overall, I don't anticipate my workload will change. But if Bountiful City does want to put more efforts on code enforcement, such as designating an employee to be that person that assertively looks for code violations instead of just waiting for people to rat on their neighbors, then that's when it will increase. In terms of staffing and resources of the legal department, we have been fortunate this year that we added Rebecca, who is a paralegal, and so we have about 19 hours of work for her that we get to delegate to her, which is fantastic. And that has been a major help. Our staffing in the legal department had not changed in 30 years, despite the various changes with laws and the things that prosecutors' offices need to do with compliance and the changes that having body camera means for prosecuting and preparing for trial and so forth. So that was a good thing to help us update it. Personally, as a prosecutor, I feel like I'm at my limit because Bountiful prosecutes Class A misdemeanors in addition to Class B misdemeanors. That means that I prosecute approximately 125 more cases a year than other similarly sized cities such as Draper or Riverton. And the only other city I know of that's our size that also prosecutes Class A misdemeanors is Spanish Fork. And Spanish Fork has 3 full-time attorneys, and their secretarial staff amounts to 60 hours of secretarial support. So we're a pretty lean machine here, which I'm sure from a taxpayer level is great. Sometimes from an employee level, it's a little challenging. We have made it through the worst year of the prosecutor's office with the COVID backlog now. Well, the floodgates were opened January of 2022 for all the trials that could not happen during COVID, which meant that I had 3 to 6 jury trials scheduled each month, in addition to approximately 10 to 15 more cases weekly that I was working through. Now that that's done, I have 1 to 2 jury trials scheduled a month, and about 10 to 15 fewer cases each week that I'm handling. So I no longer work Saturdays, is what I'm saying. So that's a very long roundabout way to say, if we keep operating as we operate, I think we can do it with what we have. If Bountiful does choose to be more assertive about code enforcement, then we probably would need additional staff.
Thank you. Thank you so much for that great information. If other council members aren't opposed, I just want to make sure we have some time for Allison to talk about the Victim Advocate Program. So are we okay to move to that?
I think so. It was
Okay.
a thrilling read. I enjoyed looking up so many of our ordinances.
Yeah, no, it really is interesting. It really is. Thank you so much for that thorough.
And I am excited for you to hear from Allison. Without her, I would be entirely lost. So with that, I'll let you hear from her directly.
Thank you.
Hey, you have the presentation. Does someone have it to put up on the screen? Great, perfect. Slideshow, yes. Okay, so thanks for having me today and taking the time to learn more about victim services. My name is Allison Sorensen, and I have worked as the victim advocate for about the past year here. And this is my first opportunity to work in victim services. So I've been learning a lot and enjoying this experience. My background is in social work, so I have a bachelor's and master's degree in social work from the University of Utah. So I've worked in adoptions, I've worked in the medical field, and I also, in addition to this victim position, I am an adjunct faculty member at BYU Idaho and Salt Lake Community College. So that's just a little bit about me. Again, I've really enjoyed this position and working with Heather, and really have learned a lot throughout the past year, and I'm excited to share a little bit about victim services with you today. So next slide, thank you. So what are victim services? I'm going to assume that I'm telling you some new information. Sorry if you've heard it before. But so in 1987, Utah State Legislature recognized that victims had some unique situations and experiences that needed to be treated with sensitivity, and they created the Victims' Bill of Rights. And in 1994, constitutional legislation was approved by our legislature. And there's many rights associated with these passing of this legislature, but some of them that are most utilized by our office is that victims have the right to be informed to the level of protection. This includes pretrial protective orders, sentencing protective orders, civil protective orders. We'll talk about those a little bit later on. The victims have the right to be informed and assisted as to their role in the criminal justice process. They have the right to have a clear explanation regarding relevant legal proceedings, to seek restitution and reparations. Victims have the right to object to the petition for expungement. So very frequently in our office, a crime was committed, several years ago, and the defendant is now requesting for that to be expunged from their criminal record. But if a victim was involved in that crime, our office reaches out to them to ask their opinion on how they would feel if that was expunged from the defendant's background. And so we try and always update them even years after the case has been concluded. Victims have the right to have a timely notice of judicial proceedings they are to attend and a timely notice of cancellations. So a little bit about Bountiful's Victim Service Program. From what I could gather, Bountiful applied first for the VOCA grant in 2017. So VOCA stands for Victims of Crime Act of 1984. VOCA funding is the federal funds that assist public and nonprofit and private nonprofit and public organizations providing services to victims of crime. So the majority of our victim service program here in Bountiful comes from this VOCA funding. In fact, we just applied and were approved for roughly $39,000 for from July of 2023 to July of 24, and then that approval will end July of 2025. We'll receive an additional $39,000 as part of that grant. So over 90% of that award goes towards the hourly wage of the victim advocate and the fringe. So the majority of what we're receiving is going to paying for the victim advocate. Victim advocate, right now I'm working 24 hours a week as part of our grant. We did up that to 29 hours a week. But I just want to make a note here that it should be anticipated that at some time Bountiful City may have to determine how much funding they're willing to contribute in addition to VOCA funding, because we are seeing that most VOCA grants have substantially decreased. Our grant did not decrease this grant cycle, but that is because we asked for such a small amount. As part of the grant process, I was asked to be on a board in which we reviewed other cities' grants. Some cities are receiving $200,000, $300,000, $400,000, and they saw their budget cut in half. And so they are now trying to find other ways to fund their positions and their services. My belief is that because our program is so small, rather than making substantial cuts to us, they just kind of kept us just funding the position itself, nothing additional. Next slide, thank you. So that tells you about the services, or kind of a history about victim advocacy. So how do I become involved with an individual? So as Heather mentioned, each week we have a court calendar. We have court every Tuesday morning, so we had it today. And there's 30 to 40 cases each week. And some of those are return defendants who have seen us several times. Others are new defendants appearing for the first time. And any case that involves a victim, it's my priority to reach out to them and speak to them before their hearing. And so what I typically do is I reach out to them and I let them know about their victims' rights, let them know that the case has been filed. Sometimes victims are involved in an incident and then they don't really know what happens after that. They don't hear any feedback. They don't know if charges were filed. And so I let them know what's going on in the case. Defendants do need to appear on most of these cases. Victims can appear. They don't have to log in. These are online hearings. And so a victim can log in, but I would say the preference of most victims is just to have me follow up with them before or after the hearing and let them know what occurred. The only time a victim will be heard at one of these hearings is if the defendant is sentenced and they're able to give a victim impact statement. So they can prepare a statement to share with the judge before a sentence is given. Some will read those statements on their own, others ask that I read it in their behalf. Heather talked a little bit about restitution. There's a couple different ways I'm involved with restitution. One is on the criminal side. So if someone was involved in a theft or were injured in some way that required them to have out-of-pocket costs, I work with that victim to ensure that we gather documentation to provide to the judge to prove that they are entitled to restitution. Another way is on traffic cases, where if someone who is uninsured is involved in an accident, and so the person who was the victim in that case has to file with their own insurance, we work with them to gather documentation about their deductible, et cetera, that's owed to them, and that is often sent as part of a sentence with a defendant that the judge will order. Pretrial protective orders. So what typically happens in domestic violence cases is that there is put into place what's called a jail release agreement. So if I'm involved with a dispute and I am charged with a crime, there's put into place an agreement that me and the defendant will not have, or the victim and the defendant will not have contact with one another until after the first hearing. which I believe is within 10 days of the incident occurring. Now, some victims want to continue that relationship or continue that contact, and so they'll come to the police station and they'll sign a jail release agreement saying that they want that dropped. Other victims want to continue that no contact, and so what we do is we file at our first hearing a pre-trial protective order where we ask the judge to not allow any contact between the defendant and the victim until the case has been resolved. So we ask for those frequently in domestic violence cases. We can also ask for sentencing protective orders, which is what we ask at the end of a case when someone is sentenced or pleads guilty or is found guilty. That typically lasts through probation, so typically 12 months after a case is resolved, victims can continue to receive protection. If they want something additional, a civil protective order, a stalking injunction, etc., we often refer those victims to Safe Harbor, which is a nonprofit organization here in Davis County that helps victims file a variety of types of protective orders to seek protection. Heather and I work very closely together discussing our victim cases. If a defendant pleads not guilty and wants a trial, Heather and I work together to coordinate interviews with victims so that we can prepare for the trial, discuss testimony, everything like that. So I'm part of those meetings and coordinating those. And then just typical questions victims will call asking them, what's going on in my case? Have you made a plea offer? What is that plea offer? We discuss all of those with victims. So that's the prosecution side of how I become involved. I also become involved in cases that have a LAP filed, which a LAP is a lethality assessment protocol. It's 12 questions that assessment performed by law enforcement at every domestic violence call, regardless of arrest. And this is something that you might have heard of recently. It's been highly prioritized by Lieutenant Governor Deidre Henderson. She had personal experience with a family member who was killed in a domestic violence situation. Her family member was seeking protection, unable to get protection, and was eventually killed by a defendant. And so what the LAP's purpose is that it tries to decide who's at high risk for a serious injury or homicide. And so if a police officer goes to a scene here in Bountiful, he has a domestic violence victim fill out a LAP and they score high, then typically within 24 hours, those LAP results are sent to me with the case number. And it's my responsibility to look up the case and then to reach out to the victim and try and make contact with them. So I can see perhaps they need some safety planning, if they're needing shelter, let them know that the case is moving forward, ask them about a pretrial protective order, ensuring that they're in a safe spot and as we work through the criminal justice system. So that's another reason which I become involved. And then there's just some examples there. The one that I want to touch on is crime victim reparations. So as part of our VOCA grant, we have to work very closely with UOVC, Utah Office of Victims, UOVC, something like that. So it just slipped my mind, but we work together with them very closely. And we have any victim who has been impacted, they can file for crime victims reparations. They can receive some funding to help them pay for medical care, mental health care. We've seen in our office victims qualify for change of locks, to pay for the locks changing on their home, to pay for cameras installed to ensure protection, to help pay a down payment on a new apartment so they're able to leave the housing that they've been sharing with the defendant or individual charged with a crime. So crime victims is very much involved in this VOCA grant and something that we collaborate with frequently with our victims. Okay, next slide. So last year, approximately 336 victims were worked with in Bountiful. I have some just information here about the victims that we served. The majority of them, as you can see, their race, they identified as white at 67%. Most other categories were less than 3% when you break those down. Males were approximately 35% of the victims that we served, 58% of them were women, and 7% of them were not tracked. And then as far as age, 25 to 59 years old accounts for 64% of the victims in which we serve here in Bountiful. So these are some of the crimes associated with the victims that I'm involved with. You can see their which ones are the dominant cases in Bountiful in which victim services are required were assault, physical assault, domestic violence or family violence, DUI cases, theft, and property crimes. So as you can think about what I've been saying, you know, property crimes, theft would often include restitution research. Family crimes would include domestic violence or pretrial protective orders, sentencing protective orders, things like that. And then, so right here is just an indicator of how, as part of our victim program, we are required to track our involvement with our victims for the grant purposes. The majority of what we do and how we serve our victims is through the criminal justice system assistance. That's that large gray part of the pie chart. And so what that is what I've been describing, checking in with victims before hearings, during restitution research, just ensuring that they are aware and up to date on what's going on in their case, helping them with crime victims applications, with victim impact statements, everything like that falls under the criminal justice system. So that's our heaviest area in which we provide services. We had indicated and recorded that 1,777 times with those 300 victims was the services that we offered in criminal justice. So that's how frequently we're checking in with our victims, et cetera. Okay, next one. So just in conclusion, domestic violence is on the rise in Utah. And there was an article today just published on KSL's website describing how the first 6 months of 2023 were the deadliest in the past 6 years when it came to domestic violence homicides. 22 people so far this year have been killed in domestic violence incidences in Utah, compared to, for example, 14 in 2022, 6 in 2021, and 9 in 2018 are some of the numbers that they indicated. So domestic violence is on the rise as a whole. It's important that cities are prepared with victim service programs that addresses the rising concerns of domestic violence and meets the needs of their victims. A victim advocate is a primary point of contact in many of these cases for the city of Bountiful. Heather's primarily responsible for prosecuting these, and a lot of her time, or prosecuting all cases, and a lot of her time is spent on preparing for those. And then it's more my responsibility to be an advocate for victims, to really understand what they're going through and to have those discussions with Heather to maximize what our office is able to accomplish. Class A misdemeanors, as Heather pointed out, are charged in Bountiful versus the county. So our office is unique in that in a lot of these domestic violent cases, they are Class A misdemeanors, but we are dealing with those victims rather than sending them to the county. So that increases our victim load, I think. And the severity of those crimes are often more complicated, take more time to work through, take more time to, during a trial, to understand some of the complications that victims have. They might be reluctant to participate. They have consequences if they do participate, including social isolation, guilt, shame, or other financial or emotional consequences if they work with our office in prosecution. And the last thing I wanted to point out is, as I mentioned earlier, there are some potential grant funding reductions that Bountiful City will, I would imagine, encounter in the future. And so I think it's important for the City Council to recognize what a victim advocate does and their role in the prosecutor's office, so that if in the future there does need to be additional funding, that Bountiful City is prepared to support that position through funding sources. So that's all I had for you today, and just if you have any questions, please let me know.
Thank you, Allison. I am sure I speak for everyone on the council when I thank you so much for the work that you do. It's so important, this position. We appreciate you so much, and all three of you. Thank you for what you do for our city. And as you mentioned, Heather, you're a lean operation, but my goodness, the amount that what you do, the ripple effects of what you do, the good in our community, we just appreciate it so much. Any other comments, council?
I just want to echo that, and thank you for taking the time, Heather, to meet with all of the department heads to consolidate everything and make sure everyone is on the same page as far as what expectations are and how you can support each other. And Allison, thanks for all that you are doing. We're happy to have Rebecca here and grateful that you can help run this lean machine as an awesome support to these two incredible women. So thank you for all that you do for our city and for anyone who finds themselves in these hard situations.
Thank you.
We're really grateful for your department. Thank you so much. It was nice to learn a little more today, and thank you for spending some time with us. We will just take a brief break before we begin our regular city council meeting.